Have you ever wondered how you can unlock new opportunities and knowledge that can truly change your journey as an African immigrant? Then, you're in the right place. Welcome to the AIM Expert series, where we bring you insightful sessions, packed with practical strategies from top experts on topics that matter most to you. So, if you're looking to grow your career or understand the US system, then grab a chair and don't go anywhere. Now, let's get started on today's session.
General information. So, anything I say will be on a general basis. If you want something more tailored to your case, you should meet a lawyer. If you ask me later on, maybe I can help you, but I'm not the only good immigration lawyer here, and you should always look for a good immigration lawyer and talk to them more particularly about your case. I will not answer personal questions maybe in any details. Clearly, people ask me questions based on their own experience during the session, but I will keep my answer again general, just because of privacy considerations, and also because, well, I wouldn't know all the facts of your case in just a few seconds. So if you want to ask me questions later, fine, but that'll be a different thing, and you're never under any compulsion to call my office. Any good immigration lawyer can give you the answers I will provide for you. So today I will talk about who qualifies to file for a green card petition for somebody. Funny enough, although I think it's a very elementary topic, but I got a lot of questions about that this past week. So I thought, okay, maybe we should go from the very beginning and talk about who qualifies somebody who qualifies to file a green card petition for a person. So it could be a person. As usual, everything is broken into person to the family side of immigration, or the business side, and maybe even the humanitarian side, because everybody who wants to live in the United States must have a reason to be in the United States. Could be you're here permanently, could be you're here also temporarily. So what can qualify somebody who is qualified to come and live permanently in the US? It's based on what is your reason? Is a business petitioning for you to come as an employee? Is a family member petitioning for you to come and join them with a green card? Sometimes the US government also has its own little humanitarian basis where they allow people to get a green card. And I'll start with the US, the humanitarian basis. The reason being, I think it's easy to gloss over it. Humanitarian basis. Sometimes the US will give somebody a green card. The one, or and when I say humanitarian, it could be just policy, humanitarian/policy reasons. For instance, the visa lottery is one of those. The US government, just because it allows people to come and get permanent resident. Basically, the US government is their sponsor, if you may want to put it that way, although they qualify you before they sponsor you. They give you that basis, so to speak, in that sense. And the reason why they do that is that they figure, hey, the US is a nation of immigrants, and people from every part of the country, of the world, want them represented in the US. So they will allow people from certain, all the countries, hey, we'll give you a certain number of visas, the diversity visas, we'll make them available to everybody in the whole world. We'll do a lottery, see if you can pick. If your number comes up, good. And what that does is that it gets people from different countries in the world and brings them to the US as permanent residents. There are some countries, though, that they are no longer allowed to take part in the lottery because the US figures we now have a lot of people from those countries in the US. Nigeria is one of those countries. I believe Ethiopia has also met its own quota. So for now, Ethiopians and Nigerians are not allowed to take part in the visa lottery anymore because there's now a lot of people from those countries in the US. And I think there's also a couple European countries in that are in that category. Sometimes too, asylum. If you've been granted asylum in the US, after a year of having that status of an asylee or refugee in the US, you're allowed to apply for a green card. So you don't need a sponsor. You don't need somebody to petition for you. Basically, the US government is your petitioner, if you may put it that way. So those are the humanitarian ways. There are some humanitarian green cards that are based a bit on family. For instance, the VAWA cases. If you have an abusive spouse or parent or child, if you qualify under those, you are allowed to self-petition. It's policy. You're allowed to step into the shoe, if you will, of the person, the US citizen family member who was meant to petition for you. You're allowed to bypass that person, step into their shoes, and file the petition for yourself. Although the US government is not your sponsor directly in this case, it's just policy allowing so that somebody who should have had a green card petition filed for them by a family member is not deprived due to circumstances. Then there are also other little ones where the people who have worked for the US government for any number of years, a certain number of years. There's one for people who have assisted the US government. Afghanistan is one of those where people who work, Afghani citizens who worked for the US, maybe translators and other positions, they were during the hostilities, if you will, in Afghanistan. They are given, the US government is their petitioner, and they're allowed to file for a green card self-petition. And I think there's a number of those ones, but that's the general, when the US government, through its humanitarian or just government policy reasons, makes it easy for a person to get a green card. Then there's the employment-based ones. We've heard about them a lot. Somebody who is your employer, an employer can sponsor somebody for a green card. And when you come to that employer-based green card petitions, it's divided again. There are some times when an employer can petition for somebody. Then also there's times when somebody is actually allowed to be their own petitioner. So let me do the one about the employer sponsorship. Generally, an employer can sponsor somebody for a petition, depending, and then you have to now split it up into the qualifications of the employee, the alien, the foreign-born employee who is being sponsored. If you have just a bachelor's degree and some years of experience, you must have a sponsor. There are also unskilled workers, artisans. Maybe you are a master bricklayer, master so and so. There's people in those kind of work, artisans, if you will. If you're considered unskilled labor, but there are certain unskilled labor jobs here that really don't have people to fill up. So an employer can file a petition for such a person, and that petition is basically the employer has to show that there's no available US workers. And if that's approved, the petition is approved, the employer, that's the foreign-born person, may now file an immigrant visa application or an adjustment of status application if they're already in the US. So in that labor sector, the thing about the employer petition too is there's a very important thing there to know. That thing is this: we have to show that by giving the job to a foreign-born person, the employer is not going to be displacing a US-born worker. So the the employer has to do a test of the labor market. This is done with the Department of Labor, the US Department of Labor. And if there's no employers who are no US-born employers who are suitable, then the employer can file that petition, the employee petition, with the Department of Homeland Security. And when it's approved, the employee who is foreign-born will either adjust status if they're already in the US, or if they're abroad, they'll get an immigrant visa and they'll come in to work for the employer. You must work for the person initially, otherwise you run the risk of later on being told that, well, you were deceiving the person. So there's a way it works. Also, an employer, they're on the employer side, an employer can petition for people who are qualified. There are other categories where an employer can petition for people who are exceptionally talented, in their careers, foreign-born persons who are exceptionally talented. Interestingly, in the employment side, sometimes a person can petition for themselves if they are extraordinarily talented. Let's say you've won a Nobel Prize, you are considered extraordinarily talented, and you are able to apply for yourself, petition for yourself. That is to say, file the alien labor petition for yourself. And you can do it without a labor certification. You just be allowed to come in. So that being the case, it's important to understand that on the employment petition side, the employer can file for you with or without a labor certification, and sometimes someone can file for themselves if they are extraordinarily skilled. There are also sometimes when you need an employer, but the labor certification is accepted. Then it doesn't have to happen, because there are certain professions that the US government says, well, there's always a shortage of workers in those professions, so that we don't need to have a labor certification. You can just file straight with the Department of Homeland Security. The nursing profession is one of those. The US government says, as a matter of policy, we always have a shortage of nurses. Physical therapists are also in that category. The US government says, as a matter of policy, we never have enough physical therapists. We don't have enough physical therapists. So for those people, they do need an employer, but the employer doesn't have to go through the labor certification business, the process. And basically, any employer who is a company, you show your incorporation, you show your ability to pay, you should be able to apply and petition for a worker. But of course, the details, let's say there's angels in the details of showing you're doing business, showing that you are able to pay wages. That's where the angels show up, and sometimes it's almost like how many angels can dance on top of the head of a pin. But it's doable. It's very doable, and it's been done. So people can petition. So the second way which can bring a person to the US is by having an employer petition for them, or in a little exception, petition for themselves if they're extraordinarily talented. Sometimes you need a certification that you will not be displacing US workers, and at other times you are allowed to dispense with that labor certification. Then comes the family petitions. When a family member can bring somebody to the US, you can come to the US based on a family member who petitions for you. Those were the questions I got a lot of during the week, and I thought everybody already knew who could petition, but for them as a relation, but apparently not everybody knows. So I'll dig into that. that particular category seems to be the category that has a lot of people inquiring and has a lot of people applying. So who can file? There are sometimes a person who has a green card only can file. But United States citizens, they can always petition for certain family members. So that's to say, US citizens can file for themselves. Can file for a bunch of family members. And US green card holders, that's to say permanent residents, can also file for certain relations. So let me say, a permanent resident, that's a US a green card holder, you are allowed to file for your spouse. You can file for your children also who are under the age of 21 and unmarried. You can also file for your children who are over the age of 21 and unmarried. So permanent residents cannot file for their parents. If you have only a green card, you cannot file for your parents. You cannot file for married children. Okay. So on the other hand, if your US relation only has their green card, they can file for you if you're their spouse or if you're their child who is not married. If that child is not married, they split that category of children, unmarried children, into two. There's a category for unmarried children under the age of 21. And there's also a category for children unmarried over the 21 and above. And of course, it brings us into priority dates and visa numbers, which is a bit of a confusing thing, but I can say this. Children under the age of 21, unmarried, and spouses of permanent residents, they are allowed they will get a faster processing date than children 21 and above of green card holders. Namdi, cut away. I need to cough. I'm recovering from asthma. Cut away.
Oh, okay. Sorry.
Cut away from me. I'm going to silence and I'm going to take off my video too.
Yeah, it's pinned you. All right, so I hope you feel better. Meanwhile, if anyone has questions, you can put them in the chat.
Of relatives of green card holders who can benefit from a petition. If you're the spouse, you can. If you're a child, unmarried, under the age of 21, you also can. If you're the child, unmarried, over the age of 21 and above, you can. And for green card holders, their children, the key really is being married. So a lot of what I've noticed in my practice is that children of green card holders, they just end up not being married, waiting for their parents so that they can remain in qualified, eligible to benefit from the green card parents or spouse, or green card parents, the green card parents status and petition for them. What happens in such cases is I tell the parents, okay, once you get a green card, when you've had your green card, the next step is try to get your citizenship as soon as you can manage it, as soon as you become eligible, apply. Because when you apply, it bumps up the kids, your relatives' priority status. So when a green card holder becomes a U.S. citizen, their children and spouse, their children under 21 become priority relatives. 21 under 21 and unmarried become priority relatives. Their spouses also become priority relatives. So that being the case, a visa number is always available for them. What it does is for them, at the same time, once they become U.S. citizens, their children 21 and married fall into a separate category because U.S. citizens are allowed to petition for their married children. So it changes up things and you just notify them. The only other way to do that thing is to make that application to naturalize once you qualify. We're not going to talk about priority dates and how it works today because that tends to get a little complex and it's best explained on a case-to-case basis. So that takes us again. So now we'll move on to the next class of people who can petition for their relatives. U.S. citizens, you're allowed to petition for all your relatives. Well, family members, and let me tell you those you can petition for. You can petition for your spouse, your children, unmarried under the age of 21, your married children, whether under the age of 21 or over the age of 21. You can also petition for your siblings. Processing times. Because that tells us, okay, well, my father is a U.S. citizen. Ask the person, how old are you? Oh, well, I'm 25. Or I'm 20, but I'm married. It puts you you're no longer, being married removes you from being an immediate relative of a U.S. citizen. So if you tell me my father is a U.S. citizen, then I'll tell you, your father can petition for you. If you're 25, you're not a priority relative. You're a preference relative. So there's a limited number of visas available every year for preference relatives. So you fall into that category. Because there's a certain number, and there's always more people wanting the visas than a visa number available, we have to put everybody on a line. And that line tends to get very long. And being a very long line is what causes the delay. So you might end up waiting about 4 years, 5 years for a visa number to become available to you. But when that time does come, it's almost like they call your number 25. You say yes. They say, okay, it's your time. Step up so you can apply for your visa. And that's how it happens. But if you're a U.S. citizen, you can apply for your wife or husband. You can apply for your unmarried child under 21, and they'll be given, they have their own line, which is the no line line. There's always a number for them, and they'll be processed faster than others. If you're a U.S. citizen, you can file for your sibling, but the number for that one that's a very long line. I think it's about 12, 13 years at this time of waiting so that you can get a visa number. But I always tell people, the important thing is to do the filing. If you're looking at the 13 years, it looks like a long time, but time does fly and you will get your green card. Just do other things. Then another, would I call it a fallout from having a family, there's something which preference relatives, that is to say, those who have to wait for a visa number to be available, those are the preference relatives. There's something they enjoy, which is this. If your U.S. relation files for you when you're coming and you're married, you can come with your wife or husband, so you can come with your spouse and any of your children under 21. So let me give you an example. You're a U.S. citizen and you petition for your sibling. 12, 13 years later, their visa number comes current and it's time for them to apply for a green card. That sibling of yours let's say it's a man and he has a wife. His wife will be included in the green card, immigrant visa which will apply for, and their children. If they have any children who are unmarried and under 21, they come with them. So that's a little benefit. If you're a green card holder, you petition for your child. Well, green card holders, okay, yeah, there's a way where sometimes their grandkid can come. So let's say you're a green card holder, you petition for your child who is under 21. Let's say the child, wasn't married but had children, has children who are under 21. They come with their kids too. So that's the sense where sometimes you see that somebody got a green card through their grandparent. It wasn't a direct filing, but the person came in under as a child of the beneficiary of a green card holder or maybe a US citizen. Sometimes somebody is petitioning for their spouse, but your spouse already had a child. Maybe that child, let's say, and that's the child who is a stepchild and not your own child. In that case, your spouse who has a child, and the child is your stepchild, will come in with their mom, who is now your spouse. I hope that's not too confusing. Then, one thing about US citizens, you must always petition for your child. So let's say you're a US citizen and you have a child, a spouse, and let's say you might even have had, there's a lot of little permutations to this, and I'm trying to narrow it down to a part, what fits. So let's put it this way. You're a US citizen. You have a spouse who has a child, who already had a child before you. That's not your child, but a stepchild. A US citizen will have to petition for their spouse and petition separately also for their stepchild. But if that person was only a green card holder, you petition for your spouse, and then they come along with their child, who is your stepchild, under them. So a little hypothetical would be this. Let's say somebody has a green card, and then they petition for a spouse, and that spouse had a child from a prior relationship, but the child is going to come along with their parent. Let's say eventually the green card holder becomes a US citizen. Once the green card holder becomes a US citizen, their petition for their child, for their spouse, it's okay, it will be bumped up to the non-preference category. But that child, you now have to file a separate petition for your stepchild. So I think I'll end it so far. I'm talking a lot. And let's take questions. I hope I haven't confused everybody much. And I see some questions in the chat.
Some of the chat.
So there's one that says, Marie asks, there used to be the case that aliens would qualify for permanent residency when they have an asset more worth $250,000 or more in the US. I can't see that anymore. It's still there. I don't know why it can't, but these days the number has changed. I don't know about 250,000, but I do know that for about $1,050,000 or so, $1,500,000 or some amount that the amount was changed. You can invest money, and that's on the employment-based side of petitions. You can invest money in the US, and that will allow you to be given a green card. The ways you can invest that money is you can start up a new business, and that business employs at least 10 people directly. you'll be given a green card first for 2 years, and then after 2 years, you'll be asked to remove condition of the green card, and you'll get your final green card, your final green card. And with your final green card, you're now, after 5 years of having a green card, you are eligible to apply to become a U.S. citizen. So, Marie, that is still applicable, but it might not be 250,000 anymore. It's now for $1 million or something. There's also they also had the time where there was a program, you could invest in the kind of pool your money with some other, they called the regional centers, but I think they were trying to do away with the regional centers. Those were really interesting. You didn't need to provide money directly. You just put your money. Some people would come with some kind of a partnership, and you pay money into the partnership, your $1 million, and you would be allowed to, you'd be part of the business deal, and you could get your green card by investing in a regional center. The purpose of the regional centers was to target and promote growth in certain areas of businesses, or a business in a certain area of the United States. You're also able to pay a smaller amount if you are investing in an area that's considered economically depressed. So
that's what I was going to wonder. The opportunity zones,
Mm-hmm.
Yeah. Okay.
Yeah. So, let's say you had that $1 million, you wanted to invest in a business by yourself only. If your business is in a targeted economic depressed area, let's say outside, find some place in the country outside of Atlanta, you are allowed to invest about half of the amount that you would normally have had to invest as a single person just trying to invest money in the US. So, but recently too, they also changed their definition. They also changed their definition of what qualifies as a targeted economically depressed area. But once you made the definition, you're in good shape. You can invest less. So I think that's the answer.
Can somebody consult with you for these type of forms, for these type of filings? Because, so I do sell houses, and primarily that's the vehicle that I used to recommend to people to fast track to citizenship or permanent residency. Now,
I'm sorry, buying a house in the US doesn't qualify you for that. But buying a house could qualify you for that if you targeted it, if you make the business arrangement is properly done. Mm-hmm. For instance, let's conceptualize. If somebody comes in here and says, I want to be a real estate investor, it could establish a business that's act in volume. You employ people, you're buying homes, and repairing maybe and selling, and that's your business. You've invested the $1 million, you've bought about 2, 3, 4 homes totaling up to that value. And you have employed people, possibly. You are now directly employing the people who are building the homes, repairing the homes, managing the homes, or managing that business. That could qualify you. Or you buy the homes, repair, and you own an apartment, a home leasing business where you have homes and you lease. So by buying a home simply doesn't qualify you. But if you establish a business in the real estate sector, that could qualify you. So that's how one can make it work in terms of real estate, houses, and getting a green card in the US. So somebody says,
I can read the question for you so you can catch it.
I love reading the questions. Although, of course, I shouldn't be talking that much. Chukwudi says, can I file for N400 with an open I-175 petition? If so, will the N400 supersede the I-70? And with the backlog of cases with a pending 751 petition, can I embark on an international trip? Can a person embark on an international trip alongside the I-751 acknowledgement receipt? The answer is yes, to number. Can you file? Yes. Can you travel? Yes. Does it supersede? No. And let me give you the details. When you filed your 751 petition, it just means that you have you've had conditional residence and you're trying to remove the condition on your residence. But the operating word there is residence. You're already a resident from the first time you got that green card, although it was given you for 2 years. If you file the condition, you should be given a letter. So if you want to travel, that letter says that your green card petition has been filed, and you will also notice that it says this letter it extends your status as a conditional resident. So if you have your passport, your old green card, and that letter, beautiful, you can try. You're allowed to travel. And once you have that letter, once you've applied to remove condition and you've been issued that letter, your green card, your time towards naturalization continues to run. Remember, even if you got the 2-year green card, which is the conditional resident card, they start counting your time towards naturalization from the first time you got a green card. So at that point of 2 years, when you filed your green card, the petition to remove condition, you already have 2 years counting towards your eligibility towards citizenship. You could decide to do the citizenship part, do the 3 years application if you're still living in marital unity with your spouse, or you can decide to wait for 5 years, depending on your situation. So let's say you filed your green card petition, the petition to remove condition on your green card. You filed it, but it's taken a long time. And sometimes it tends to take a very long time. It's almost like my feeling is that the USCIS may think, well, we've extended your green card. That's not the one that class of application is not the one they really want to put in priority basis. So I've seen cases where 4 years later, 4.5 years later, they haven't got their green card removed, the condition removed. Yes, you can petition to naturalize. So let's illustrate. Let's say your spouse petitioned for you. You got a 2-year green card. You're living with your spouse, waiting. 2 years has passed after you filed the petition. So that's now like 4 years since you first got a green card. Yes, sir, you should petition. You should apply to naturalize. You can and you should. What it does is this. The naturalization application does not supersede or wipe out the need for the green card, the removal of condition. But what will happen is that you'll be invited to an interview for naturalization. When that naturalization interview comes up, you're going to most likely find out that they'll bring up your green card, the petition to remove condition, and they'll be done on the same day. So first of all, they'll ask you at your interview, they'll ask you, can I see your paperwork for removing condition? You show it to them. Do you have extra paperwork? They'll ask you questions based on that form. Once they finish, then they'll ask you your naturalization questions. And you may even get, depending on what you have on file, and maybe sometimes the start at the level of the interviewing officer. Sometimes if you have a supervisor level person interviewing you, you might actually get both of them approved on that same day, and you just jump into you'll be issued a date for your naturalization ceremony. So you'll get 2 approval letters, one approving the removal of condition and the other scheduling you for a naturalization date. So does that answer the question, Mr. Chukwudi? Let me see, Chukwudi is there.
Yes, it does answer the question. Thank you very much. Okay.
And Robertson says, is there a path for TPS holders to get a green card besides employer sponsorship? TPS is a discreet thing. It's just something that allows a person to remain in the US because of the situation in their country. When the situation in your country changes, you go back and TPS is removed. You will go back to your old status, whether the status or lack thereof, which you had before you got TPS. Let me illustrate. So let's say somebody came in as a tourist let's say you're Cameroonian, because Cameroon has a TPS status now. You came in as a tourist, you overstayed, you just never left, but you did come in with an I-94 card, but you didn't have any other avenues for a green card. And you've been living in the US without a green card, and then this TPS, Cameroon TPS, is given you. That Cameroon TPS will allow you get a job, get an employment authorization. It just lets you live and work in the US while things are not good in your country. Let's say in 2-3 years' time, the US government says, okay, Cameroon is okay now, it's back stable. They will terminate TPS for Cameroon. And if that happens, that person is now back to their status before they got TPS, which is to say, well, you didn't have a status. You were just hanging out, you overstayed. Okay, so that's it. You can work during TPS. While you have TPS, you can get a job with any employer. The interesting thing about marriage situations, though, is this. Let's say while you have TPS, you get married to a US citizen if you're lucky, and you get a petition filed for you. You just end up getting your green card. And even if your country's TPS status is removed, you still have a green card. There's been issues about, there's also people, sometimes you snuck across the border. You came in through the border, you didn't see an immigration officer, and you've just been living in the US. Then your country gets TPS. Then you get TPS because of that. So long as the TPS status remains, you're allowed to work. But if your country's TPS status designation is removed, comes to an end, you go back to being that person who snuck in across the border and who cannot adjust status because of it. Let's say that same person gets married to a US citizen. You still cannot adjust status in the US because you didn't come in with permission. In that case, there's been a little tug of war. Well, if you have that TPS and you get advanced permission to travel, you travel out, you come back. Does that allow you to? Can we now say you made a legal entry? And sometimes the DHS will say yes, that's considered a legal entry. And once you have a legal entry, boom, you can now remain in the US and apply for a green card. I hope it doesn't confuse too much, the answer.
Yes, ma'am. Well, I know there's one more question, or cutting close to time, and so I will say thank you very much, Ma, for your time and really pushing through, muscling through this, muscling through to give us.
It's always a pleasure. I had an asthma attack about I think going on 3 weeks ago, and it's always recovering from it. That's an issue, but I'm doing good. Thank you.
All right, I'm glad you're doing better. So if you still have questions, again, on Circle, you can share those. Even though it's up, it's not down, but there's something off with our domain. So we're working to fix that. But if you registered for this through Zoom, you should have been invited to the platform that immediately the confirmation, you should have received an invite to Circle. So please go ahead and accept that. It's not spam, it's an actual invitation. That's where all of our announcements are and everything. Join that group and keep updated with everything going on within the African Immigrant Collective. We have the sessions every week on different aspects, different areas, and spread the word. Let people know that this is what we're doing. And yes, but for today, we'll call it a day. Thank you all for spending some of your Saturday with us. And we will see you again next week. Before we go, I want everyone to mark their calendars for December the 8th. December the 8th, it's a Sunday. By 6 p.m., we'll be having our end of year gala. We'll be announcing details of that as we go on. But mark your calendar for that. It's going to be a day of celebration of our journey so far. So we're excited about the progress we've made and the things to come in 2025. We'll be sharing all of those. So keep watching for more information, but we have to run now. So thank you very much. We'll see you next Saturday. Go with it.
Thank you. Thank you.
Thank
Bye.
you.